Hello friends, very warm welcome to my business laws channel. So friends, in the last video lecture class, I started Sale of Goods Act. Till now, I have covered the very first chapter under the Sale of Goods Act. Today, I'm going to take up second chapter, which is chapter number 16, and the title is Transfer of Property. So friends, what is property? You all know friends, when we talk about contract of sale, then we do talk about ownership. It is a ownership which is transferred from the seller to the buyer. So you all know the meaning of the term property, property in goods, because I have taken this heading under the heading, I have taken this term under the heading essentials of a contract of sale. So by property, we mean general property. And by general property, we mean the ownership. And special property, when we talk about special property, means some interest. As you know, the pledgee has some interest in the goods which are pledged by the pledger with the pledgee. So friends, there is difference between general property and special property. And property in goods should also be distinguished from the term possession of goods. Friends, remember, when we talk about possession of goods means control of goods, custody of goods. Servant may be in possession of goods, but it does not mean that servant is the owner of goods. Ownership lies with the master. So servant is just having the possession of goods, or he is having the control over the goods. So these two terms are very different. One is general property or the ownership or property in goods, and second is friends, possession of goods, control of goods or custody of goods. Moving ahead, friends, now it is very important to know the precise moment of time when the ownership has to pass from the seller to the buyer under the contract of sale. Now the question arises, why it is very important? Why should we know the time at which the ownership has to pass from the seller to the buyer? 4 reasons for this. One is risk prima facie passes with property. Second is action against the third party. Third is insolvency of the seller or the buyer. And fourth is suit for recovery of price. Risk on the face of it always passes with property. If property has passed, if the ownership has passed, it means risk has also passed. Whosoever is the owner at the time of destruction of goods has to bear the loss of destruction of goods as per section 26. If ownership is with the seller, he will bear, and if the ownership has passed from the seller to the buyer, then the loss has to be borne by the buyer. Coming to the second point, which is action against the third party. Any person who tries to cause loss to the goods, it is the owner who has the right to sue the wrongdoer. Third is insolvency of seller or buyer. Whether seller becomes insolvent or the buyer becomes insolvent, there is official receiver or official assignee, officer who is appointed by the court. Then in that case, official receiver of seller, is he bound to deliver the goods to the buyer or not? It depends. It depends whether the ownership has passed or the ownership has not passed. And similarly, is the buyer bound to pay the price or not? Buyer's official receiver bound to pay the price or not? To the seller, it depends whether the ownership has passed or the ownership has not passed. In other words, we can say, are we talking about sale transaction or we are talking about an agreement to sell? The last point is suit for recovery of price. Can the seller recover the price from the buyer or not? If the ownership has passed, then the seller has the right to recover the price from the buyer. But if the ownership has not passed, if there is any default on the part of buyer, then the seller can only recover damages. He has no right to file a suit against the buyer for the recovery of price where the ownership has not passed. Now friends, moving ahead, I will take up the heading now, which is rules regarding transfer of property. Now, this heading I would like to discuss under two subheadings. First one is specific or ascertained goods, and second will be unascertained or future goods. So you all know, friends, under the very first chapter, I taught you classification of goods. We can classify the goods into three categories: existing, contingent, and then future goods. Existing goods again fall under two categories: specific or ascertained goods, and then unascertained goods. Specific goods, which are identified and agreed upon by the buyer or between the buyer and the seller at the time of formation of contract. Buyer is very clear in his mind. He goes to the showroom, he buys, say he wants to buy a car. He has selected the model, the color, everything. He's satisfied, and he has made up his mind and he has entered into the contract regarding buying of car. So that car will fall under the category of specific or ascertained goods. So what are the rules regarding ownership transfer in case the goods are specific or ascertained goods? So it always depends, friends, upon the intentions of the parties. So the very first point is property passes. Property means ownership. Ownership passes when the parties intend to pass. Say the parties, buyer and the seller, they have intention that ownership shall pass when the payment is made, or the ownership shall pass when the goods are delivered, or the ownership shall pass when both the parties perform their respective obligation under the contract. But what will happen, friends, if intentions are not very clear? Then there are certain rules which have been laid down under sections 20, 21, 22 and 24. And then these rules will apply when intentions of the parties is not clear. So let us know these rules now. The very first point is where the goods are in a deliverable state. Now the question arises, how can we say the goods are in a deliverable state? Friends, goods are said to be in the deliverable state when the goods are ready for delivery. No action is to be undertaken by the seller, to keep the goods ready for delivery. The goods are ready. And then in that case, the moment seller informs the buyer, you come and take delivery of goods, at that very moment, the ownership shall pass from the seller to the buyer. Now coming to the second point, which is where the goods have to be put into a deliverable state. Here, friends, goods are not ready for delivery. Some action has to be undertaken by the seller to put the goods in the deliverable state. Say he has to insert the goods into the packets or containers or tins. Okay, then the moment he does that act and he informs the buyer, it means he has put the goods in the deliverable state. So then the ownership shall pass from the seller to the buyer. Now, third point is where the seller is bound to wait or measure or test or do some other act in order to ascertain the price. Say cotton is lying in the godown, but cotton has to be inserted into the bales. Bales are to be made. So then the moment the rice, quantity of rice is lying in the tins, and now it has to be measured in order to ascertain the price. The moment it is done, the weighing is done or the quantity has been measured, it has been inserted into the boxes or tins or packets, then and the seller has informed the buyer thereof. At that very moment, the ownership shall pass from the seller to the buyer. And the fourth point is where the goods are delivered on approval or sale or return basis. Where the goods are sold on approval basis. If they are approved by the buyer, it will amount to sale, and if they are not approved by the buyer, it will be returned to the seller. Or buyer can inform the seller, no, I have not approved the goods. There's an important case law regarding this, which I would like to share and discuss. That is Elphick versus Barnes. In this case, the seller sold horse on sale or approval basis to the buyer. For 8 days. The horse was to be tried by the buyer for 8 days. Now, on the third day, When the horse was in the possession of the buyer, the horse died. And now the seller wanted to recover the price from the buyer through the court of law. It was held in the court of law that seller had no right to recover the price from the buyer because ownership had not passed from the seller to the buyer. I would like to take up more points here. If the 8 days period expire and then horse dies in the custody of buyer, then it means after the expiry of 8 days, the ownership has passed from the seller to the buyer. Now the loss has to be borne by the buyer. So friends, or on the 4th day or 5th day, buyer has sold that horse to C person. And now in the possession of C, the horse dies. Buyer has sold the horse on sale or approval basis. And in the possession of C, the horse dies. Then in that case, the loss has to be borne by the buyer. Because, giving the horse on sale or approval basis by B to C, it means he has accepted the transaction. So friends, I hope you must have understood all these rules. And if you have any doubt, you can always write in the comment section. Now friends, I would like to talk about how are the goods ownership transferred in case the goods are unascertained and future goods. Unascertained goods, as the name implies, the goods have not been ascertained yet. They have not been identified yet. Maybe the goods are not in existence, or the machinery is to be produced, or the goods are to be acquired by the seller, or the machinery is coming on the ship, or the fruits are to be grown, vegetables are to be grown. Then when the ownership will get transferred from the seller to the buyer. Here I would like to explain two terms. One is ascertainment of goods and second is appropriation of goods. Now these ascertained goods, the moment goods are ascertained or appropriated, the goods which are answerable to the contract, they are appropriated by the seller with the consent of buyer or by the buyer with the consent of seller. And the buyer is informed thereof. At that very moment, the ownership shall transfer from the seller to the buyer. Ascertainment of goods. The goods, say 50 computers are lying in the godown. Out of 50, 10 computers, Acer computer, the buyer wants to buy. And now 10 Acer computers have been set aside. They have been identified. They have been set aside. They have been separated from the entire lot. This is meaning of the term appropriation of goods. But friends, ascertainment of goods must be distinguished from appropriation of goods. When we talk about ascertainment of goods, it is unilateral act of the seller. Appropriation is setting aside the goods which are answerable to the contract from the bigger lot. Now, when we talk about appropriation should always be valid. Now the question arises, what are the essentials of valid appropriation? The very first point is it must be of answerable goods which are answerable to the contract, quality-wise as well as quantity-wise. And parties should have the intention to determine specific goods. It must be performed by mutual assent. It may be express or implied. Assent may be express or implied. And it must be unconditional. Unconditional means no condition should be attached. And now, friends, I would like to explain what is the meaning of unconditional. Now, appropriation is said to be unconditional when the right of disposal has been reserved by the seller. Now the question arises, what is the meaning of reservation of the right of disposal? It means the right to dispose of the goods with conditions imposed by the seller. Now when these conditions are fulfilled, then only the ownership will be transferred from the seller to the buyer. That is, the right to dispose of the goods has been reserved by the seller. It means here the ownership shall not pass unless and until the conditions are fulfilled by the buyer. When the seller reserves such a right, the possession in the goods does not pass until these conditions are fulfilled. He may experience such right by terms of the contract or appropriation. And now, friends, the seller may reserve ownership in the following two ways. How can he reserve the right to dispose of the goods, even when the goods are delivered to courier for transmission? The goods are, goods are to reach from the seller to the buyer through common courier. Common courier may be railway authorities, shipping authorities, air authorities. So I'll be using the term courier, common courier for transmission. The goods are delivered to the common courier for transmission. So how can the seller reserve the right of disposal? In two ways: by holding the bill of lading or railway receipt. Goods have to reach from the seller to the buyer through ship or train, railways. He can, give the instructions that the bill of lading or the railway receipt has to be issued in the name of seller. In the name of seller means he has reserved his right. And second is he has given in the name of, he has the bill of lading or railway receipt has been issued in the name of buyer, with instructions have been given. But instructions have been given that when the buyer will honor the bill of exchange, then only these goods are to be delivered. So some conditions have been attached here. So then the right of disposal is said to be reserved. So friends, I hope you must have understood the meaning of how can the right of disposal be reserved. If he doesn't take the bill of lading or the RR in his own name, he takes in the name of buyer and no condition is attached, then the right of disposal is said to be unreserved. It is unreserved, it is unconditional. Then the ownership shall pass from the seller to the buyer, provided we have provided all essentials of valid appropriation are there. So friends, I would like to conclude now. Till now, I have discussed the rules regarding transfer of ownership in case the goods are specific or ascertained goods. And then second one was where the goods are unascertained or future goods. Very important question I would like to take up now. Nemo, that, Quod, none, Habet. No, non-owners, they are not allowed to make a valid sale. So this is the Latin maxim, which means the person who is not the owner, he cannot make a valid sale. This is the meaning of Latin maxim, Nemo, that, Quod, none, Habet. Or we can say the seller cannot transfer to the buyer of goods a better title than what he himself has. But there are some exceptional cases where this rule is not applicable. That is, even the non-owner can pass a better title. So let us study now these all 8 to 9 points which are exceptions to the rule Nemo, that, Quod, none, Habet. The very first is, friends, transfer of title by estoppel. Estoppel means to deny the fact. Estoppel means a person says something, he is bound by his words. Say S person is selling the goods within the presence of D, who is the owner. D is the owner of goods, S is not the owner of goods. Now S is selling the goods within the presence of D. He has sold the goods. So then D should object to this because these are mine goods. But he is not objecting. Then in that case, the sale which is made by S will be termed as valid sale. He has not said anything, but he is behaving in such a way. He is not objecting. Then S will pass a better title to the buyer. Second is sale by mercantile agent. Mercantile agent, you all know, friends, is not the owner of goods. He is the agent who has been appointed to sell the goods on behalf of the principal. Even then, he always transfers a valid title to the buyer. The case law is Fox versus King. Now, in this case, F has sold the car to G person and he has told G, his agent, not to sell the car below the reserve price. But even then, you know what happened? G sold the car to K, King, below the reserve price. And now F came to know that the car has been sold by his agent to K person. And now he filed a suit against the K for the recovery of that car. Case went to the court of law. It was decided by the court judges that F was not having any right to recover car from K because his agent G passed a valid title to K person. So friends, the conclusion is that sale which is made by mercantile agent is termed as valid sale. Next is sale by a joint owner. Anybody who is not the single owner, but say motorbike is owned by two persons, A and B, and one of them makes a sale. He sells that motorbike to C person. Then C will always get good title to the goods. Though the C will become the owner, valid buyer of the motorbike which has been sold by one of the joint owners. Next point is sale by a person in possession of goods under voidable contract. So you all have studied, friends, this voidable contract term under the heading kinds of contract. Voidable contract is one of the kinds of contract on the basis of validity. Voidable contract is one which is enforceable at the option of one or more of the parties thereto, but not at the option of other or others. Say for instance, B has got car from A, second-hand car, at gunpoint. A is the seller of car and B is the buyer. B has obtained possession of car from A at gunpoint. So B is in possession of contract. B is in possession of car. A has got two options. A's consent has been caused by coercion. Now A has two options to exercise, but he is taking time to decide. Now B, in the meantime, B who is having that car under a voidable contract, he sells that car to C person. C doesn't know, C acts in good faith. Then C will always get good title to the car. B was not owner, but even then, he passed a valid title to C person. Moving ahead, sale by seller in possession of goods after sale. Goods have been sold by the seller to the buyer, but seller is still under possession of goods. And that seller has sold the goods to another buyer, say B1. Now B1 acts in good faith. B1 is under the impression that seller is the owner of goods. He has no knowledge of the earlier transaction between B and S. S is a seller and B is a buyer. Then also, friends, seller was non-owner, but even then he passed a valid title to B1. Moving ahead, next is sale by a buyer in possession of goods after an agreement to sell. And now the goods are in the possession of buyer. Ownership is with the seller, but goods are in the possession of buyer. And now, buyer has sold the goods to C person. Because he was in possession of goods, C has acted in good faith, thinking that buyer is the true owner. Then in that case, C will get good title to the goods. Buyer was non-owner, but even then, C will get good title to the goods. Then sale by unpaid seller. Friends, unpaid seller, as it is clear from the term itself, unpaid seller means the seller who has not been paid the price. Which price? Part of the price or whole of the price. Unpaid seller is last chapter under the Sale of Goods Act 1930, which I will take up in detail. But unpaid seller is a seller who has not been paid. So one of the rights which is available to the unpaid seller is right to sell the goods. In some cases, in those cases, the seller has the right, he can sell the goods, and the sale which is made by unpaid seller will be termed as valid sale. Then exceptions under other acts. Other acts are ICA, Indian Contract Act, Companies Act, Insolvency Act, or Negotiable Instrument Act 1881. Under Section 169 of ICA, this Section 169 of ICA deals with the finder of goods. The finder of goods under Section this 169 and 176, they deal with the, one is with the pledge of goods, other is with the, finder of goods. If pledger has pledged his goods with the pledge and he has not paid the amount on the due date, then pledgee is not the owner, but he has a right. He can sell the goods in the market and realize his amount of debt. And finder of goods also, finder of goods is the owner. He is not the owner of goods. Finder of goods must find out the real owner. If after making all efforts, he has not been able to find out the real owner, then in the eyes of law, he becomes the real owner. And he has the right to sell the goods in some cases. He becomes the owner. He has the right to sell the goods in some cases. If the goods are perishable goods, if the owner is not traceable, then or he is traceable but he refuses to pay the lawful charges, then in these cases, finder of goods may sell the goods, and sale by him will be termed as valid sale. Under Insolvency Act or Companies Act, Insolvency Act, official receiver may be appointed, official assignee may be appointed in case the person becomes insolvent, or liquidators may be appointed in case of company's liquidation. They are not owners, but they will, when the company goes into liquidation or the person becomes insolvent, then all assets, liabilities of the insolvent person, they are transferred to official receiver or assignee. They may sell the goods. They are not owners, but they will sell the goods, and sale by them will be termed as valid sale. Under Negotiable Instrument Act 1881, HIDC. HIDC stands for holder in due course. Holder in due course is a person who is the holder, who has obtained the instrument in good faith before the date of maturity and for valuable consideration. So friends, holder in due course has to satisfy the condition which are given under Section 9 of the Negotiable Instrument Act 1881. So holder in due course title is free from all defects. If he has obtained, he fulfills all the 4 conditions which are given under Section 9, then in that case, he becomes, even if he has got the instrument from the person who was not the true owner, but he will always get good title to the goods. So friends, now I would like to wrap up this heading. Question may be asked, non-owners cannot make a valid sale. Explain and state the exceptions. Or Nemo that Quod and Habet, explain the meaning of this maxim and state the exceptions to the rule, to this rule. So friends, you will start from the statement, write all the points with the explanation and examples, and then you have to conclude. Conclusion must be there, because in statement form questions, good beginning and then the matter, and then after that, it should be well concluded. So friends, I hope this is all from my side. I hope you must have understood the content. If you have any query, any point which is not clear to you, you can always write in the comment section. Do like my videos, do subscribe to my channel, do press on the bell icon, so that you can get notifications of my subsequent videos. Okay, friends, keep smiling and stay blessed always. We'll meet soon. Bye-bye.